Fundamental Principles and Rights at Work, more particularly the Declaration of 1998 that was amended very recently, as you rightly evoked, was at first met with a number of criticisms. And it's very interesting to look down 25 years down the line or more and see the type of reality that it generated with its application. So this declaration that was generated in 1988 at the request of ILO tripartite constituents generated a huge change in the traditional ILO framework, in the sense that it generated obligations and commitments that were inherent to the ILO membership, without passing by, so to speak, the usual ratification or adhesion of the instruments. So the commitment contained therein is to respect, promote, and realize fundamental principles and rights at work. In a presentation that looks very scary, but that I will use very shortly, you will see what principles we're talking about and what instruments are related to them. So the interesting aspect with those fundamental principles and rights at work is that they concern human rights that have lived beyond the world of work, so to speak, and also they constitute enabling conditions for the achievement of the 4 ILO strategic objectives that you probably referred to yesterday. So we're talking about obligations in terms of objectives, so obligations of conduct, but also obligations of results, if we are going to use the human rights lexicon. And that makes it all the more interesting in light of the recent developments. So this, I do not know how to say it shorter, fundamental principles and rights at work have a number of characteristics that for some of you will echo what you have heard in the global human rights protection framework. I.e., they're universal, they're immutable, they're inseparable, they're interrelated, and they have a mutually reinforcing character that is very difficult to exemplify. For a very simple reason, we are accustomed to look at each of those principles and rights as a single element, without taking into account the different intersections that should be addressed at the same time. Those rights required, because of all those different intersections, an integrated approach to achieve their realization. For instance, and such approach, if I may say, will differ from one right to another. For instance, in the case of forced labor and child labor, you will see an express requirement to take measures of a legislative kind within the criminal/penal sphere. While in the case of certain types of rights that are enshrined in the fundamental conventions related to equal opportunities and treatment, what you will see is rather the suggestion to refrain from solely combating discrimination by using the criminal or penal arena. So some complex rights indeed. The 1998 declaration, as amended last year, is a non-binding text, which makes it very interesting in itself. We're not within the framework of international labor standards. Those are basically, this is an instrument that derives its authority from the solemn affirmation of principles of universal and lasting importance. Why is this important? Apologies for the double importance here. Because upon joining the international organization, member states are saying, this is what we believe in. Hence, the obligation to give effect to those principles and rights, and also to report. Mind you, it's not the same reporting system that we're accustomed to when we ratify an instrument. So there is a promotional follow-up for the member states that have not ratified one or more of the conventions considered as fundamental. And one of the purposes is to identify need and offer technical cooperation and assistance to the member state. So please bear this in mind when I go to my last slide, when we're going to attempt to make some uncomfortable questions relating to our fundamental principles and rights at work. So it's actually history, short history, has shown us that this declaration that was so questioned because it would be a watering down of the very complex and perfected system of international labor standards existing within the ILO ended up being a tool for integrating core labor standards in framework policies, strategies created by non-state actors. We typically refer to this as the privatization of labor standards. So, and now I'm not saying something new, but this was absolutely unthinkable 25 years ago, when in order to actually be discussing in the context of a free trade agreement issues relating to the so-called social clause, you had to negotiate aside, not as part of the main agreement. Now, we can see fundamental principles and rights at work present in free trade agreement, whether they are bilateral, the usual type, whether they are sub-regional, or how we call it in the Americas, by blocks, or whether they are regional. So you also will find them in the UN Guiding Principles on Business and Human Rights, on the OECD Guidelines for Multinational Enterprises, the UN Global Compact, and Corporate Social Responsibility Code, which is really not bad for something that is not binding in essence originally. So basically, what you as ILO constituents managed to do is to enter the sphere of commerce. May I remind you that under the WTO, the only obligation that member states had originally related to labor standards was not to compete against one another using prison work. So this has generated a completely different game when it comes to negotiating, when it comes to who is actually supervising what you do, because it's no longer the traditional supervisory bodies. You may be supervised by a body that you've contributed to creating yourself, that has no one representing the state on it. And that's the CSR structure. So this looks very scary, but don't mind, this is just for illustration purposes. I'm not going to go through it. It is quite barbaric, and I apologize. The point is to have you see the 5 different fundamental principles and rights at work, the 10 conventions and 1 protocol that give life to those rights, but more importantly, that very word cross that I put in the middle. Why? When we're looking, for instance, at equal opportunities and treatment, we may not be looking at the impact it has when it comes to child labor. What's the difference between a girl that is 7 years of age and a boy that is 7 years of age when it comes to the right to education? That right to education is can be assessed under 2 different instruments or 2 different principles. Those relating to equal opportunities and treatments, because we may make things a bit more complicated. Maybe it's not just a boy and a girl. Maybe it's a boy who belongs to an ethnic minority. Maybe it's a migrant worker. You have all kinds of contexts that are more relevant to your countries as you come across the examples. So you have 2 principles in this very simple scenario that I'm giving you, which are child labor and equal opportunities and treatment. So I'm going to attempt to very quickly go, too quickly, I apologize, through what is contained in those fundamental principles and rights that we so much speak of. So when it comes to freedom of association and collective bargaining, we have 2 instruments, Convention 87, Convention 98. As you know, those are not the only instruments that exist when it comes to those topics and to industrial relations, but please humor me. So we have different objectives. On the one hand, to protect the autonomy and independence of workers and employers' organizations in relation to public authorities. And on the other hand, Convention 98, to provide adequate protection against any acts of anti-union discrimination, as well as adequate protection of workers and employers' organizations against any act of interference by each other. And I forgot, I apologize, I will modify it, I forgot the promotion of collective bargaining, which is the 3rd objective within Convention 98. In the case of the elimination of forced labor, We have, as indicated earlier, 2 conventions, 1 protocol. The protocol, I understand, has only been ratified by 1 of BRICS member states. Originally, Convention 29 and Convention 105 were based on the assumption that the main offender was the state. In some cases, it still is the case. But we came up, I like the we, I was not involved. You came up as ILO members with the protocol in order to actually bridge the gaps. So the purpose of Convention 29, I will not read the official objective, which is taken from its provisions, rather is to consider forced or compulsory labor as any forms of service, work or service, required under the menace of any penalty and involuntary work. What does it mean in effect? It means that when you are addressing certain aspects that have to do with labor discipline, such as, for instance, labor discipline in the context of seafarers, i.e. maritime work, or in the context of fishers, you need to be looking at those fundamental principles and rights under forced labor. Because the menace of penalty is very concrete in that particular context. So the protocol, I apologize, I don't know in which order they come. The protocol came in order to bridge existing gaps when it came to preventative action. Convention 29 is the result of a mandate that was given to the International Labour Organization by what was not yet to become the Society of Nations. To do what? To explain what was the difference between forced labor and slavery in the context of the Slavery Convention. So, what's the problem with this? Well, none, except that you are looking at it from the perspective of criminal law. And from the perspective of criminal law, you are looking at the need to sanction and penalize an offender. You're not looking at the victims, you're not looking at prevention, and you're not looking at protection and compensation. Most importantly, in the recent efforts, you're not looking at the labor and employment aspects of what has to do with trafficking for the purposes of forced labor. Typically, we speak of trafficking for the purposes of sexual exploitation, if we speak about it at all. Forced labor is completely forgotten. So, therefore, the efforts, both nationally, regionally, and even within different continents, are absolutely hindered because we're not talking the same language, whether juridically or otherwise sometimes. So when it comes to Convention 105, once again, we're back to forced labor, but this is at the hand of the state for a particular purpose, which I could summarize as saying silencing opposing voices. Why is it interesting, particularly in the context of another fundamental right and principle, that of freedom of association? Because it also concerns situations where it is utilized as a sanction for participating in strikes. And once you have a look at the actual provisions, you will see that there are a number of subparagraphs that are related to the exercise of civil liberties that are inherently connected to that of freedom of association and collective bargaining. I've never been so fast. I apologize, but I'm very proud as well. So what's the purpose behind Convention 138? Twofold. One, to protect children from labor. Labor the way child labor is understood, i.e. not work, but second, to protect children while at work. So this is the provision that you can find. One of the interesting aspects of this convention is that the idea is not only to ensure the effective abolition of child labor, but also to progressively raise the minimum age. Or should I say minimum ages, because this convention has been around for a considerable amount of time. It has been widely ratified. When we get to technical cooperation and assistance, we will see that child labor is overtly present in efforts of technical cooperation, and yet this convention is not really well understood. So there are links between child labor and education. I just evoked them earlier. There are links that also have to do with, for instance, children living with HIV or children orphaned by HIV, that puts them at very particular risks of being engaged in child labor. And so it is a very complex instrument that warrants the presence of people beyond the world of work. So you need to see it with the equivalent of your Ministry of Justice, your Ministry of Defense, and so on and so forth. And that's where, in that particular context, that's where we saw the appearance of tripartite plus fora. So Convention 182 requires to take immediate and effective measures. So we're talking about a number of things, all forms of slavery or practices similar to slavery, prostitution, the production of pornography. All of those are fairly obvious, I should say. But then we're talking about something, and this is just for your takeaway, illicit activities. It's all good and well when we're thinking about kids that are 4 years of age carrying out bricks, the way we all have the image. Walking like penguins because they're so tiny that they cannot actually walk in properly. It's an all different ballgame when we're talking about teenagers that are involved in drug trafficking, in other types of criminal activity. Then we are very reluctant as a society to see them as victims. So this convention, once again, we are within the realm of criminal law, but also we're taking into account the most recent developments when it comes to child protection. So, when it comes to equal opportunities and treatment, Convention 100, if any convention in the ILO is to be referred to as a gender convention, this is the one. It deals with the principle of equal remuneration for men and women for work of equal value, only between men and women. It entails a number of things. 2 levels of examinations, so at the level of the job, is the job of equal value? It sounds very simple, but it does require an objective analysis that cannot be done just by anyone. And second of all, is that remuneration equal? And I should say, thirdly, what constitutes remuneration? Because it's not that obvious either. Some very interesting cases, when you see the connection between freedom of association and equal opportunities and treatment, have to do with collective bargaining agreements that entailed clauses that violated those principles. So a lot of work to be done still. Convention 111 aims to declare, requires member states to declare and pursue a national policy to eliminate discrimination at least on the basis of the 7 grounds. It's very rare for a country to actually include all 7 grounds in its national legislation. What's interesting is actually what is known as the additional grounds. So basically that's when South Africa sits down and say, okay, for South Africa, this is a prohibited ground of discrimination. It could be seropositivity, whether real or perceived. It could be disability. It could be a number of things. And that's when you're actually domesticating this convention and making it yours. Apologies, I say conventions, that's one of the problems of the job when you get an ILS specialist to comment on this. So, apologies, I'm just going to go back. Why is it very important in light of other instruments? Because it goes way beyond what we understand as work. It includes education. So we're back to the child labor aspect. Vocational guidance and training. Do people that have different characteristics have the same opportunities when it comes to what is it that I'm going to study? What are the options awarded to me? Is it a productive type of employment that is going to be at the end of my training? So this is really linked to all the topics we've seen before. The terms and conditions of employment, it is a certain degree of complexity. As you can see, now that I'm in the most recent Rights and Principles, I've tried to focus on what are the similarities. So, and this is strange. Both conventions provide, there is a huge focus on prevention. They provide for a national policy. You have the accurate wording on the slide. They set out general principles for the establishment of a system approach to OSH management. Both indicate the actions to be taken at the national and the undertaking level. This OSH is particularly interesting for a very simple reason. OSH can only be improved via collective bargaining, via the true exercise of freedom of association, and yet it is also a way to actually improve freedom of association and collective bargaining, or at least consultations and cooperation depending on the actual right. So it emphasizes the participation of employers, workers and governments through express provisions, and highlights their complementary role. OSH is one of those rare subjects when it comes to standards, when you're going to expressly see what the obligations of a worker are, whether we're talking about general conventions, whether we're talking about sectoral ones. And last but not least, upcoming development, we have how is this resolution that's elevated OSH, or safe working environments, to the level of fundamental principles and rights that were going to be implemented. First of all, there is the follow-up for those that have not ratified the two instruments, one or both. It's referred to as baselines. Basically, those are reports that are presented before the governing body. So how is the follow-up to the declaration going to occur? Second of all, in the context of the regular supervision of the application of ratified international labor standards by the ILO, particularly regular supervisory mechanisms, how is it going to look like? How are they going to work the reporting cycle? Is there going to be a new report form? More after March. And this is, I would dare to say, the key takeaway. What is pending? What is the homework that is still pending? First of all, we need to identify the gaps in terms of budgeting and investment. I had a couple of statistics regarding ILO. I'm not going to bore you with them. I know that they do not represent the efforts undergone in your respective countries, but they are quite illuminating, I would dare to say. So child labor, there are currently 223 projects in the world on child labor. The second in this, on this podium is forced labor with 53 projects. I'm not going to go into the level of investment in terms of billions of US dollars. The third one is discrimination with 31 projects, and the last one is freedom of association and collective bargaining with 21. I am quite aware that this is not the picture that you have in your countries, but this is the picture we have internationally. This is without including, because it would be unfair, the latest fundamental principle and right. So if we're saying that they're interdependent, what are we doing when all our efforts are being focused on child labor? I'm not saying forget about the children. Obviously, the Durban Global Conference took place recently. There was a very important outcome. But we need to keep in mind that these fundamental principles and rights at work need to be moving hand in hand, and that is not the case if we assume that we put our money where our mouth is. So, not fundamental rights and principles, they're not equal among themselves. Second of all, because they're not equal among themselves, that has a direct impact when it comes to technical cooperation and assistance. As you could see from the document that was distributed prior to the meeting, we have huge lacunas when it comes to the statistics, particularly when it comes to forced labor. But I think that if we were going to look a bit further regarding all those rights, we would find additional absence in the statistical picture. So in terms of coordinated and sustained efforts, both nationally and across borders, we need to be in a position where we can identify and also take into account, first of all, the complexities of the global supply chain within the regions that you represent today, but also within your countries and within your own sub-regions, and also the cross-boundary character of the violations, the offenders, and the victims. I thank you very much for your kind attention.